Okay, very good. Welcome back. Hope you all enjoyed your weekend. While we were on the weekend recess, did anybody watch, read, listen to any news accounts or social media posts related to this case? Talk to anybody about this case or do any independent investigation on this case? All right, no one's raising their hand. I'll take that as a no. Okay, I have just a quick introduction as far as the jury instructions. Members of the jury, you have found each of the defendants guilty of one count of first-degree murder. The only issue before you in this phase of the trial is to determine the appropriate penalty. The penalty for the crime of first-degree murder is either life in prison without the possibility of parole or the death penalty. Before proceeding further, it will be helpful if you understand how this proceeding will be conducted. The attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. What the lawyers say, however, during opening statements is not evidence, and you are not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendants may present evidence. Witnesses may be called to testify under oath. If so, they will be examined and may be cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. This evidence, along with the evidence that you heard during the guilt phase of the trial, is presented for you to determine whether the state proved beyond a reasonable doubt the existence of the alleged aggravating factors. If so, you must weigh whether the proven aggravating factors outweigh any mitigating circumstances the defendants proved by the greater weight of the evidence. Finally, you will decide whether each defendant should be sentenced to life in prison without the possibility of parole or to death. At the conclusion of the evidence and after argument of counsel, you will be instructed on the law that will guide your deliberations. An aggravating factor is the only circumstance recognized by Florida law that could result in a defendant receiving the death penalty. An aggravating factor increases the gravity of a crime or the harm to a victim beyond the harm inherent in every first-degree murder. You must unanimously agree that an aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your sentencing decision. The aggravating factors alleged by the state in this case are: as to defendant Rashad Murphy, first aggravating factor, the defendant was contemporaneously convicted of a felony involving use or threat of violence to a person. The second one, the defendant knowingly created a great risk of death to many persons. The third one, the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And 4, the capital felony was committed by a criminal gang member. As to defendant Isaiah Chance, as to first-degree murder, the first aggravating factor is, as alleged by the state, the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. The second aggravating factor, the capital felony was committed by a criminal gang member. As to defendant Sean Gathright for first-degree murder, the first aggravating factor is the defendant was contemporaneously convicted of a felony involving the use or threat of violence to a person. The second aggravating factor, the defendant knowingly created a great risk of death or harm to many persons. 3, the capital felony was a homicide and was committed in a cold, calculated, and premeditated murder manner without any pretense of moral or legal justification. As to defendant Davion Murphy for first-degree murder, the state alleges the following aggravating factors. 1, the defendant was contemporaneously convicted of a felony involving the use or threat of violence to a person. Second, the defendant knowingly created a great risk of death to many persons. Third, the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And four, the capital felony was committed by a criminal gang member. Once the state has presented evidence of the existence of aggravating factors, victim impact evidence may be presented. Such evidence is only presented to demonstrate the victim's uniqueness as an individual and the loss to the community by the victim's death. However, victim impact evidence must not be considered by you as itself an aggravating factor. A mitigating circumstance can be anything that might indicate the death penalty is not appropriate for a defendant. It is not limited to the facts surrounding the crime. In other words, a mitigating circumstance may include any aspect of a defendant's character, background, or life, or any circumstance of the offense that may indicate the death penalty is not an appropriate sentence in this case. Whether a mitigating circumstance has been proven is an individual judgment by each juror. A mitigating circumstance need not be proven beyond a reasonable doubt, but must be proven by the greater weight of the evidence. After the evidence has been presented, I will give you instructions on the law. The attorneys will then have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, I will then conclude with final instructions to you. After the final instructions are given, you will begin your deliberations. Again, you should not form any definite or fixed opinion until you have heard all of the evidence, the argument of the lawyers, and the instructions on the law. Until that time, you should not discuss the case amongst yourselves. Your decision must be based solely on the evidence or lack of evidence and the law. During the penalty phase, the court may take recesses and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone or permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about the case, tell that person at once that you are on the jury and ask that person to stop. If that person persists, leave that person at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during recesses, but even then you may not use your cell phone or electronic device to find out about any information about the case or communicate with anyone about the case or the people involved in the case. Again, do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside of the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact phone number has been provided to you. The penalty phase must be tried by you only on the evidence presented in your presence and in the presence of the defendants, the attorneys, and myself. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you're in the courthouse, at home, or anywhere else. You must not visit places mentioned or use the internet to look at maps or pictures to see any place discussed during the penalty phase. Jurors, again, must not have discussions of any sort with friends or family members about the case or the people and places involved. Do not let even the closest family members make comments to you or ask questions about the penalty phase. In this age of electronic communication, I want to stress again that just as you must not talk about this case face to face, you must not talk about this case by using an electronic device. You must not use your phones, computers, or other electronic devices to communicate about this case. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. As we discussed previously, what are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, I have no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and to challenge the evidence being considered against it and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having the opportunity that our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. Again, in every criminal proceeding, a defendant has the absolute right to remain silent. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference regarding the existence of an aggravating factor or an appropriate sentence. And the fact that a defendant did not take the witness stand must not influence your sentencing decision in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor would a witness might have said had the witness been permitted to answer. It may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as is necessary. All right.